This is Valerie Guillaume, and I'm here to expose the corruption that's going on in the Canadian courts. I mean, right now I'm dealing with the court in Brampton, Ontario, and I'm here to expose the corruption, the incredible corruption that is going on, and human rights abuse that's going on at that court right now that I am aware of. I am going to expose in this video a couple of judges and also the clerks in that court, because they're all working together to abuse my human rights and to block me in my current legal proceeding with the Regional Municipality of Peel, which is the local government. So I'm going to expose some judge, starting with Michael Emery. So, and then I'm going to expose after him another judge by the name of Suranganie Kumaranayake, an Indian judge, who of all people should know what it's like to be discriminated against, but she's a racist bitch. I have no respect for the judiciary because they have no respect for me as a member of the public. I was in her courtroom today. She was having a hearing in 308 in Brampton Court, Civil, and I was there to file. Actually, I'm going to deal with her, and then I deal with Emery. I was there to file an urgent motion, and she would not let me come in the courtroom to file it, according to the clerks. And then I said, go back and tell her under Section 15 of the Charter and under Rule 37-10, subsection 2, I do have the right to bring this urgent motion to the court today. It's not that, because I'm very well familiar with the procedures of the court and the directions, practice, procedure, and directions of the court, okay? But Rule 37, 3, subsection 3, I'm sorry, I think I mentioned 10 earlier. No, that has to do with the filing of documents like affidavit, which I'm also going to get to in this video. But I was there under Rule 37.3, which is urgent motions. Now, urgent motion, according to subsection 3, can be set down for a hearing on any day. You can have a situation where you have an urgent motion that has to be heard by the court ASAP. And I've talked to lawyers in the past, and even some of them have advised me, look, if it's really that urgent, then just go into the court and just try to see the judge. Okay? But in my case today, I sent my urgent motion to be filed yesterday. And I put the hearing date. I wanted a hearing date for October 10th, which is today. And I wanted to do it in person, so I just made my way to the court. And this woman did not want to see me. Later on, she claimed that she had no materials, motion materials before her, which was not surprising because the court did not respond. Before I left the court today, I was talking to the team leader there who said she was going to try to have a judge review it, because that's usually what happens when you send your motion in, including urgent motion. The administrative judge or whichever judge like to review it and then give instructions on that, and that's going to get back to Emery. So this judge here, this Indian judge by the name of, what's her name? Kumaranayake. I'm going to file a complaint against her with the Canada Council, Judicial Council, because she violated my charter rights under Section 15, legal rights, okay? And she was dismissive, didn't want to hear the motion, and I had to go before her and I said, look, I have a right to be heard. I'm not saying that I can force this judge to hear my motion. Actually, under Rule 37.3, it states that if you have an urgent motion, you can go before a judge and the judge has to hear it. Okay, now sometimes what happens is that the judge, especially if it's not before, if the clerk did not present the file to the judge, and let's say the judge has a long list that day, which you may be waiting hours, but some people are prepared to wait hours. Because I was waiting hours, I was prepared that my urgent motion was going to be addressed today. So sometimes the judge have a really long case list. Sometimes they don't have the materials in front of them, which is what this judge was claiming. But that's not even why I was upset. I was expecting some kind of thing like that, okay? Because these things happen. I wasn't expecting to walk into the courtroom and demand that the judge hear my urgent motion. No, sometimes they will just basically hear what you have to say and then give instructions on what's going to happen next. It may be that she believes or he believes that the urgent motion can be heard another day, again because of their caseload or because they don't have the materials in front of them. So I wasn't going in there demanding that she absolutely has to hear the urgent motion. I just wanted to be heard, which is my right, meaning I wanted to have access to the courtroom so that I go in there and said, listen, I have an urgent motion and I want to know if your honor would be able to hear that motion today, which is usually what a lawyer says. So because I'm not a lawyer, she didn't want to entertain me at all. And she lied. Listen, this judge lied, because when the first thing, I was so mad. The first thing I said, I just walked past the people in the court, like the guard, the clerk, whatever they are, you know, and like, I need to speak to this judge because you're telling me one thing outside, so I need to hear it from the judge directly if she doesn't really want to speak to me today about this urgent motion, because she should. Under the law, she should. As I said, even to just speak to me briefly, it is my right as a member of the public. It is my right to be able to bring an urgent motion before the court and for it to be heard. Okay. So I was exercising that right. And as I said, you go in there hoping that it will be heard, but sometimes there are situations such as overload, or they don't have the materials where it may not be heard on that day. So I was also prepared for that. But I wasn't prepared for anybody telling me you can't go into the court because you know, the judge doesn't want to hear your stuff today. No. The judge has to hear my stuff today. The judge has to hear what I have to say. I have an urgent motion. How do you want to proceed on this? So she was being a bitch, and I'm calling this judge a bitch because I don't respect her, because there's a conspiracy going on at that court. Normally, I am respectful of the law and of the court process, and many judges will tell you that. I'm always respectful in the courtroom. But when I see people, whether it's a police officer who is disrespecting his badge, dishonoring his badge, or when I see a judge acting so much against the interests of the public and also disregarding somebody's constitutional rights, I do not have respect for that kind of person. And this is one of those judges right now. Her name is so hard to pronounce. Kumaranayake. That's her name. And I think her first name is Suranganie or something like that. Okay, I should have written the first name down as well. So she basically said, and she walked out of the courtroom. And then why I had to make this video, I asked for her name after she left the courtroom because I didn't know her name. I asked for her name from the clerk. They lied. They said her name was THOMPSON, the last name. I forgot the first name that they told me, but I know the last name they said was THOMPSON. That was not the name of the judge. So I went downstairs and I asked the, you know, the person that you ask for instructions and get slip to see, go to the counter and do your legal work, documents and stuff. I asked one of them, what is the name of the judge in 308? And I was told it's Kumaranayake. I said, it's not Thompson. She said, no, it's Kumaranayake. I said, okay, well, it does fit the description. She is Indian, and it does fit that, and that person. You know, I mean, you can be Indian and have a English-speaking name, but she did fit the description of the name given to me by the people downstairs. So, as I said, the clerks in the court should not have lied to me about the name of the judge. Maybe they think I'm some crazy person who comes in there or something, or somebody who was not familiar with the law or something. I was upset about that. That's a breach of public trust. That's a really, really disgusting thing for them to do. Just tell me the name of the judge, the real name of the judge. They can be charged with breach of public trust. It was a total disrespect to me to do that and to infringe on my rights in this way. So now, let me tell you what led up to this urgent motion that I wanted to file in the court today. So, there is an eviction order. Okay, so I'm appealing the decision of the single motion judge. My previous video, I went into detail about that, about the judge, single motion judge Trimble J, who was the case conference judge, who heard the motion of the Regional Municipality of Peel, who wanted to lift the automatic stay. So he heard it, and I have a problem with a lot of things he's done. I have a problem with the fact that his decision in hearing that motion, and keep in mind that he was the case conference judge in regards to the situation. So he was familiar with the case. He was case managing it, okay? So there's always the possibility of a presumption of bias when you have a case management judge, which is out of his jurisdiction actually, under Rule 50, 13.13, I think. It's outside of his jurisdiction to case manage it and then to go have a full hearing. Not just a hearing, because sometimes case management judges do make motion hearing that about things. Sometimes the parties agree on it, and okay, they, you know, at the case conference, people, you know, issues are discussed, and sometimes both parties will agree, like, okay, fine, well, that can be done in the motion. But he made himself the judge hearing the motion that's gonna finalize the issues of my matter in the court, which should really go before a panel, or at least very least before another judge other than him, because he was case managing it. So what's happened is that my appeal is before the divisional court, and it's been perfected. It's been accepted by the court, so I'm now waiting for an appeal date. The mandatory order which Justice Fowler-Bryn made on the Regional Municipality of Peel to house me into the shelter is the whole purpose of this appeal, because Stuart J. lifted that mandatory order, and of course I went and appealed it. So the whole argument that Peel want to relocate me outside of the region and evict me from the shelter, I mean, you know, I'm going to get back to this later. So let me go back to the judge, Michael Emery. So when Trimble J made the ruling against me to lift the automatic stay, which he claimed did not apply to my situation, only the cost part of the order applies, right? Because Peel won the motion, so the loser pays. So he's not recognizing the substantive part of the motion, the order, as the automatic stay applying to. So I file a motion to set his decision aside. I file a motion to set aside and to vary his order, which is going to go before the panel. In the meantime, I filed a motion for a temporary stay until my motion to set aside his order gets to the panel. Okay. I sent that to the court for filing. Then on October 8th, I heard from the court in the morning, you need to file your affidavit in the motion record. Fine. I responded, okay, I will do that today. And they were even suggesting that I filed the affidavit of service. That's what actually mentioned. So I said I'll go to the, and I think in my last video as I mentioned at the end, I'm going up to the court to commission the affidavit. Okay, so what happened when I was at the court, the clerk, I'm showing you how corrupt they are. The clerk, Marianne Anna, who was commissioning my affidavit, and I was, now the counter closed at 11, then it reopens at 2 p.m. till 4. So I was there in the afternoon, and she was commissioning my affidavit, and would you believe the woman just only wrote her first name, Marianne, on the affidavit document, not her last name, and then had the nerve to hand it to me. What is troubling about this is not the first time she's done it. She did it a couple of months ago, and I said, what is this? This is a legal document. I need both of your names on there. And I reminded her again yesterday. I said, I need both of your names on there, your first name and your last name. You're the commissioner of oaths. You need to sign it with your first and last name and stamp it. So she took it back and she signed her last name to it. I'm showing you how little respect they have for me in that court, and how little respect they have for my rights. So while I was there, I left there something to 4, because remember I said the counter closed at 4, and it's a busy court, right? So when you go there, you have to wait. I noticed when I checked my email later, because I was going to go and do upload the affidavit to my motion record as I was requested to do earlier that day. They sent me an email at 4:30 p.m. okay, saying that they took my motion for a stay before a judge, who is now Michael Emery. He wants, because I didn't have the affidavit in the motion record, he now denied my motion for a stay. And then gave the instruction that I not only have to do that, I have to also provide an affidavit in support of the motion under Rule 3710(2). And that's what's happened. The problem I'm having with this is that it's an urgent motion. The situation requires that the motion be heard as soon as possible. Because of my situation, because this is a lot of work on me, it's a lot of strain on me, the affidavit in support of the motion, some judge will not make a big deal of it, because it really says under, I think, C 37.10(2)(c), I believe it says, if there are affidavit evidence that you've served, that you served on the respondents, it should be included in the motion record. I didn't serve any affidavit on the respondent, because basically what we're saying in our motion is stuff we've said previously, because this is ongoing for months now. And so there really wasn't anything new in our motion materials. Okay, it's mainly trying to interpret the law, and or have the judge interpret the law, such as with the automatic stay pending appeal, because I filed my appeal and the automatic stay was granted by the registrar pending the appeal, and appeal went to file their motion saying that it did not apply. Okay, it only applied to costs. And Trimble J, the problem I have with Trimble J is that he stated his opinion at the case conference airing on June 9th, that he didn't believe that it applied, and he carried that opinion throughout case managing it, and also now at the motion hearing itself, which he shouldn't have had himself heard that motion hearing, because he was biased against me, openly biased, and also the presumption of bias. Okay, but that was clear by his comments from day one, which he has never changed, and that affected his decision. The other problem I had with him was being the case conference judge, and also having being the judge, also hearing the motion to that's gonna finalize the situation here. Okay, so that's a problem there. and obviously it led to a lack of procedural fairness. So obviously I was going to have his order set aside, which I filed a motion to do that. Okay, but it's all a conspiracy. So Emory now stopped my motion for a temporary stay until my motion to set aside is heard by the panel. So yesterday I filed another urgent motion asking directions from the court how to proceed, and also asking for Emory J's order to be stayed, because he stayed the motion for the temporary stay against Trimble J's order. And the reason why Emory J stayed that motion was because the clerks in the court went to him and said she did not provide an affidavit in her motion record. The problem I have with this is that they made that request on the 8th. I was at the court trying to comply with that request. And before the end of the day, they took my motion to the judge for him to deny it because I didn't have the affidavit in the motion record. The clerks did not even give me 24 hours to comply with that. It's not like they said you need to put that in your document by the end of the day, which they couldn't have told me because they're not the judge anyways. But they did say to me, have that amended. And I was at the point of doing that when they went to the judge to stop my motion for a stay. So you can see the conspiracy. Now I filed that. I was asking directions from the court, asking to stay Emory's order, also asking to stay so I can get legal aid lawyer, somebody, because I now need someone. And it's not like I haven't tried before, but now I really need legal aid because it's too much on my physical medical condition, and also it's really, really a lot of work to do that because he really want that affidavit to be done. I want to point out that with an urgent motion, you can dispense with all of this formality if it's a really urgent situation and if a delay would cause you irreparable harm. So that's one of the things I asked for in the motion that I filed yesterday, to dispense of the formalities that you would have to do with a regular motion. I asked for that, which would also include filing an affidavit in support of the motion. I asked the court to dispense with the regular formalities with a regular motion, also asking for direction, also asking to stay the order of Emory, Michael Emory, and Trimble J. So they were not, because their goal as part of the conspiracy is to see me harmed. So they were not entertaining this. So when I went to the courtroom of this woman this morning, and I was prepared to stay all day, because like I said, when you're doing an urgent motion like that and you're going into the court, you need to be prepared that you may have to wait a long time to have your motion heard, or just try to have it heard. Okay, and I said I wasn't going in there demanding that the judge heard me today, in the sense that she has to hear the full motion and make a decision today and all of that. No, because I know things happen, right? But this judge had no excuse today. I want to add this. When I went over to the civil list and they said go to the civil list, she only had 2 other cases on the list, and both of them were finished early today, I think by 2 o'clock. So she had the rest of the day to hear my motion. This is why there's no excuse against this judge, Kumaranayake. So the other 2 cases, I sat outside the courtroom and I waited, and I said, if I have to wait till 4:30, 5 o'clock, I'm going to do that, because I want my urgent motion to be heard today, because of the fact that the automatic stay was lifted by Trimble J, and there's an eviction order that will be imposed upon me, and that is going to cause me irreparable harm. And this judge, Trimble J, had the nerve to say in his endorsement that he knows that there's a likelihood that I will suffer irreparable harm. He also says that if that end up to be the case with his decision, then the panel can reinstate me. Okay. So, and there's another problem with his decision also, in the fact that Peel Region really has no legal authority to relocate anyone outside of the region of Peel. And this judge did not say that with Peel working with other municipalities is the same as them working outside of their service area. He also did not consider my charter rights, especially section 6 and 7. My mobility right to live anywhere I want to live in this country of Canada, and to get the services and to have a livelihood in that region. Peel region is infringing on that, okay? My charter rights under Section 7, the right to life, liberty, and the security of person is also violated because I will suffer irreparable harm. He didn't think I met the test under RGR McDonald Supreme Court ruling, which clarifies the test on for stay. He didn't think I met it. He didn't think I would face irreparable harm, which is contradictory to his own damn decision, where he stated that in the case that I end up being homeless after his order is made, then I can go to the panel of judges who's going to be hearing my appeal, and they can reinstate me back. So he knows that he's going to cause me harm, irreparable harm. I clearly I clearly met the test for irreparable harm. There's a serious issue to be tried, and I would suffer irreparable harm, and the balance of convenience favors that, meaning that I'm going to be facing more harm than the respondent, Peel region, which is the local municipality. It's going to face no harm. I'm the one who's going to be homeless. Okay, so this corrupt judge, Trimble J, I won't go into a lot of details about him in this video because I did with the last video. This other one, Kumaranayake, Emery. So this all of this confusion was going on at the court today, with me not being able to have my urgent motion heard. Okay, so I went to the counter, and then the team leader came out and says, well, I'm not aware that you filed this second motion, urgent motion, so I'm going to go over it, and I'm going to let you know at the end of the day. I'm going to bring it before a judge. I said, which judge? Please do not bring it back. Please do not bring my urgent motion now, the second one, before the same judge that I'm asking the court to stay his order, which is Emery, Michael Emery. Okay? She goes, well, you know, this is the court, and I can't really say, because the obvious thing is that if he's going to bring back my second motion before the same judge who stayed the first one, that's going to be prejudice against me, okay, obviously. So I said, please do not bring my matter back before that same judge, because I'm already asking in this motion to stay his motion, okay. And I left it at that. She said she's going to get back to me by the end of today. Everything about my situation is urgent, and these people at the court are treating it like it's nothing. They want to cause me harm. It's a part of the conspiracy. You need to understand, and I cannot say it enough, the level of corruption in the Canadian courts need international intervention. They don't have the authority to interfere in the Canadian judiciary, the judicial system. But they do have the authority when they start infringing people's international human rights, inherent human rights, which they're doing to me. One of those human rights that they are violating for me is the fact that I cannot get lawyer or counsel to represent me facing this eviction. Under international human rights law, under Canadian law, I am entitled to have counsel to represent me when I'm facing an eviction. That was not the case. So a lot of my rights are being violated. I wanted to mention this video today because let me go back over some of the things I said earlier. The clerk at the court in Brampton, the civil intake court, Anna, sign my affidavit document without putting her last name on it. I had to give it back to her and said, what is this? Please sign it. This is a legal document. And then she put her last name on it. It was not the first time she's done it. It concerns me that I also brought this issue to Lisa Weiss, who is the regional director for court operation in that region. Asked her to look into it and to get back to me, especially to ensure that my urgent motions are filed in the court so I can proceed with this urgent matter that I'm facing. She didn't get back to me. So they're all ignoring me and all disrespecting me because they want to see me harm. Please take note of what I'm saying next. I do not care about your title. I do not care if you're a judge. I do not care if you're a director. I do not care if you're a minister. I am going to prosecute you in the ICC. Hear me and hear me well. This is a stated fact. I am going to take those actions to protect my human rights and my life, because my life may not be valuable to you, but it is valuable to me. And I have that right under international human rights laws. If these government officials take those actions against me, against the Rome Statute, like crimes against humanity and torture and some of these things that they're doing against me, they can and will be prosecuted in the ICC. And in case you doubt me, I have been to the ICC previously with other Canadian officials. This is my second time. So I'm not joking. It's a game to them. This is how evil and wicked it is. Sometimes God gives me the strength to continue, but there are times when I'm like, this is overwhelming. They know about my medical conditions that I have. And I don't even like to talk about it because it's a violation of my privacy. But sometimes I have to mention it, like these people are doing things against the fact that knowing that this woman is going through these things. And only one or two judges, Justice Andre and Justice Fowler-Bryn, recognized the fact that, okay, this woman has a pre-existing medical condition. And Justice Fowler-Bryn put it in her order in regards to maintain me in my bed at the shelter if I'm admitted at a hospital and things like that. But Justice Andre recognized that just being in a homeless shelter is irreparable harm in itself. That's why he granted me the injunction. I'm stuck there because Peel has cut off my subsidy for no reasons other than to block my legal proceeding with the landlord, Park Property Management, because of the conspiracy that exists between its property manager Barzan Slayman and Christian Commons, and also the region of Peel, because you need to understand that they had direct connection to the regional municipality of Peel, the landlord, because of the subsidy. Peel pays the rent directly to them. So they were in communication with Peel throughout this process. The second thing you need to look at is the timing of when they wanted me to be relocated, because I've been in contact with the region of municipality of Peel for months, because I was a resident of the shelter. Never once, as God is my witness, never once did it ever come up about them relocating me out of the region of Peel or evicting me from the shelter. Never once. The first time it came up was days after I got the injunction to stop the landlord from renting me the place. Then I got that notice from Christian Common: you're going to have to move out of the shelter. We're going to relocate you outside of the region of Peel, and I'm ending, your subsidy is going to be ended. All three. They never mentioned before this legal proceeding with the landlord about relocating me out of Peel. Do you see that based on the balance of probability, more probably than not, that Christian Commons made that decision to interfere directly with my legal proceeding with the landlord. That's exactly what it is. Because they were never making this argument before, we want you to be relocated out of the... How dare they? How dare that bitch? So I'm fighting it with all that I've got, and I'm going to be continuing to make this video because it is a matter of public interest. When someone who is self-represented cannot have their charter rights respected in the courts. If it was a lawyer today who had gone into the court and said, you know what, Your Honor, I have this urgent motion and I would really like to know if you can hear it today. No, they didn't want to hear she didn't want even to speak to me today. I had to, like, what is this bitch doing? I do have a right to be heard, right? I'm not saying that she's gonna have a full hearing of my urgent motion, which she should, because under Rule 37.3 it says even if it is a long motion, as long as it's an urgent motion, and she knows the circumstances of this urgent motion, that it should have been heard. It says urgent motion can be heard on any day, even if it's a long motion, right? But like I said, if you're familiar enough with the court and you're really going into the court, and if the judge have a long caseload that day or don't have the materials in front of him that day, you going in there expecting that there could be the possibility that your urgent motion won't be heard today. That was also in my mind, because I don't know the court schedule. I don't know the long list that they have to work with. But you go in there taking your chances. I just wanted the opportunity to go into the court and say, look, Your Honor, I have an urgent motion that I really would like to have heard today. But at the same time, I was being reserved to say, okay, maybe she's going to put it for another day, or maybe she's really going to look at the urgency and hear it today. I wasn't really putting any demands on her based on the availability of the courts and stuff like that. We know. But for her to say, I'm not hearing her urgent motion and don't want me to come into the court and present my case, no, you can't do that. You're violating my charter rights. And then she's gonna say, no, I didn't say that. Well, either you lied, judge, or the officer in the court lied, because somebody said that to me. So it may be that the misunderstanding was based on what was told to me by your officer in the court. So in that way, you have this little leeway, which you were using against me, saying, I think you misunderstood. I didn't really say you could not come into the court. Blah, blah, blah. I'm like, okay, yeah, bitch. I'm university educated too, bitch. Not just you. That's what I was thinking. I know what you said, or your officer said, which is against my charter rights, section 15, specifically, my legal rights. So it really bothered me, because you're dealing at the end of the day with discrimination. Not just systematic discrimination, but discriminating against me too, because I'm self-rep. In the sense that I'm going to be treated differently from a lawyer. I already know that, but I'm doing my best. Okay? So work with me on that. Respect my charter rights. Respect my rights as a human being, my right to life, liberty, and the security of person. And respect the fact that I'm doing my best regarding my situation here, because it is causing me harm, and it's going to cause me irreparable harm. But the wickedness and evilness of these people who are running our court system, they don't care. I was outside waiting to go in, and one of the lawyers came out and was saying to one of his clients, listen, she don't care. She doesn't care about emotions. You're not going in there based on emotion. You're going in there based on the freaking legal work that you've done. You're putting a demand on the court and saying, this is my rights. This is what the law says. This is my situation. because it makes no sense for you to go in there and get emotional. They're not going to base their decision based on the fact that you're emotional. Okay. So I had to come and make this video about this corrupt judge and about the court in Brampton that's completely blocking my situation, wanting the regional municipality of Peel to put me out on the street as a homeless person. And it shouldn't happen to anyone. Endangering my safety. And so I had to make this video. So this is Val reporting against human rights abuse in Canada.